Hello. On behalf of Express Legal Forms, LLC, I would like to discuss transfer on death deeds.
This is a PowerPoint presentation of the frequently asked questions regarding transfer on death deeds. First question, what does a special transfer on death deed do? When you die, the specified property will transfer to your named beneficiary without probate. The deed has no effect until you die. You can revoke it at any time. It's important that you recognize which states transfer and death deeds are valid. An important consideration is whether transfer and death deeds are valid in your state. Below are a list of those states which presently authorize transfer and death deeds. Does a transfer and death deed avoid probate? It avoids probate on any of the properties you specify in the transfer and death deed. On your death, the property belongs to whoever you deeded the property to. Thus, there is no need for any probate on this property. This is the reason some attorneys refer to this as a poor man's trust. It is inexpensive and accomplishes the avoidance of probate costs. Some general terminology. The beneficiary is the person who receives the property on your death. He may be known as a designated beneficiary or as the grantee. This can be an individual, corporation, trust, joint venture, LLC, or public corporation. The transferor is you, the individual who makes the transfer. The property owner may also be known as the grantor. There are certain requirements for a valid transfer and death deed. It must contain the essential elements and formalities of a properly recorded inter vivos deed. A deed like you would make if you were selling your home. You must state that the transfer to the designated beneficiary is to occur at the transfer's death, and it must be recorded in the public records in the county where the property is located before the transfer's death. All the requisites of the deed except the present intent to convey the designated beneficiary. If you have property in more than one county, you need to record in all counties. What is not required? Notice, delivery, or acceptance by the designated beneficiary during the transfer's life. In other words, you do not have to tell the designated beneficiary that you've done this, and there is no consideration for the designated beneficiary required. Who may be a transferor or grantor? You as an individual may be a transferor. A corporation, business trust, estate, trust, partnership, limited liability company, joint venture, etc. may not be a transferor. There's distinguishing language in a transfer and death deed. That is, that your transfer to the designated beneficiary is to occur at the transferor's death. The effect of a transfer and death deed during your life. Prior to the grantor's death, in other words, prior to your death, it does not affect your creditors, encumbrances, liens, deeds of trust, or other title matters. You may convey the property to another, may make any change to the title, may revoke, may replace with a different deed, and may encumber with a mortgage. In other words, you can do anything you were doing at the present time. The designated beneficiary's creditors cannot attach the property because the beneficiary has no interest in the property as long as you're alive. Prior to the grantor's death, in other words, prior to your death, the recording of the transfer and death deed does not give the grantee, in other words, the beneficiary, any rights or any interest in the property. A judgment, a divorce, a bankruptcy, and anything else related to the beneficiary cannot affect the property while the grantor is alive. Does the transfer on death deed create any interest in the designated beneficiary? No. The deed does not create any legal or equitable interest in the designated beneficiary. What happens when you die? The grantee, in other words, the beneficiary, or whoever you're deeding it to, must be alive at the time of your death. If there are multiple grantees, in other words, you deeded it to 4 of your children, the share of the predeceased grantee goes to the other grantees. At the time of the transferor's death, in other words, at your death, title of the property is transferred automatically to the beneficiary or beneficiaries. The grantees, those that are take subject to any conveyances, encumbrances, assignments, liens, or other interest in the property. So if you have a mortgage on your property, it doesn't clear this mortgage. There's still a mortgage on the property. The beneficiaries receive only whatever interest that you had owned at the time of the death. And always, the transfer and death deed has no effect until your death. Can you transfer your home? Yes, the deed can be used to transfer most residential properties, a condominium unit, or farmland with a home. Some states have special restrictions such as agricultural land over 40 acres or business property. Do I need a legal description of the property? Yes, this may be attained or supplied in a number of ways. The legal description is on your deed. It may also be on your title insurance policy. How to identify the legal description in the deed. If you don't know, there's a short video in the transfer and deed section of expresslegalforms.com. Go there and we'll walk you through obtaining the legal description. What are some of the requirements to make sure the deed is good? 1, you must have it notarized like any other deed, and you must record the deed in the county where the property is located, and you must record the deed shortly after you sign it. How to record the deed? Take the completed and notarized deed to the county recorder where the property is located. What if I own the property with others? The deed only transferred your share of the property. In other words, if there's 2 of you, you transfer your share. It doesn't affect the other person's share. If the other owner or owners also want to name a beneficiary on their death, they must complete and record a separate transfer and death deed form. What is the effect of a transfer and death deed for property that you own as a joint tenant or community property with a right of survivorship? If you are the first joint tenant or spouse to die, the deed is void and has no effect. In other words, if you own this property jointly, then this transfer and death deed would be of no validity because by the prior deed, the joint tenant or spouse acquires the property. If you are the last joint tenant, in other words, let's say your spouse has already died, then the deed takes effect and the property is transferred to your named beneficiary. Can you revoke a deed if you change your mind? Yes, you may revoke the deed at any time. That's a big advantage of these transfer and death deeds. How can you revoke the deed? You're going to revoke the deed by any one of 3 ways. You file a revocation of the deed with the county where the property is located, make a new transfer and death deed. In other words, you change your mind, you want to give it to somebody else. If you make a new transfer and death deed, the old one's no good anymore. You can sell or transfer the property before your death and record the deed. Your transfer on death deed only affects property that you own when you die. Will my last will and testament revoke my transfer and death deed? No. A transfer and death deed cannot be revoked by your will. My beneficiary is pressing me to sign a transfer and death deed. What should you do? Do not create a transfer and death deed if you are being pressured to do so. Does the beneficiary of the transfer and death deed need to know about the deed? No. This allows you to change your mind at a later time without causing any hard feelings. After my death, what does the beneficiary need to do? The beneficiary needs to record evidence of your death. What if I name several beneficiaries? Your beneficiaries will become co-owners in equal shares as tenants in common. What if one beneficiary dies before I do? If all beneficiaries die before you, the transfer and death deed has no effect. If one of the beneficiaries dies before you, but other beneficiaries survive you, the share of the deceased beneficiary will be divided equally between the surviving beneficiaries. Is the property still subject to my debts or mortgages on the property? Yes, it is. Does the transfer and death deed avoid gift and estate taxes? No, these taxes are calculated according to law. Who pays the property taxes after I sign the transfer and death deed? The deed has no effect on your property taxes until your death. At that time, property tax law applies as it would any other change of ownership. How to prepare a transfer and death deed? If you desire to prepare a transfer and death deed, then go to www.expresslegalforms.com. Open the section for transfer and death deeds. It will walk you through, ask you questions so we can prepare a transfer and death deed. Thank you for watching.